Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We are here this afternoon for the submission of two cases by oral argument, and the first case is Bradshaw Renovations versus Barry and Jacqueline Graham. And it looks like the parties are ready. Mr. Hemphill, you may begin.
Thank you, Your Honors. May it please the court, opposing counsel. My name is Matt Hemphill. I'm an attorney for the appellant and the applicant, Bradshaw Renovations, LLC. This is a consumer fraud case presenting two straightforward issues. Number one, what constitutes willful and wanton conduct to justify an award of statutory treble damages under Section 714H.5 of the Iowa Code? Number two, what constitutes an ascertainable loss necessary to prove a consumer fraud claim under Chapter 714H. Our position in this case is not challenging the weight of the evidence. Our position in this case is, where is the evidence? I'd like to dive right into the statutory text here, Chapter 714H. What is required? What is the plaintiff, in this case the Grahams, what did they need to prove? They needed to prove that the defendant, my client, Bradshaw Renovations, engaged in a prohibited practice that caused an ascertainable loss such that they could recover actual damages. Prohibited practice is addressed, not exactly defined, but it is addressed what constitutes a prohibited practice in the statute. It must be done with intent. Intent for reliance upon by the plaintiff to their harm. It's more than mere negligence. It's more than a breach of contract. What does ascertainable loss mean? This court has weighed in on this issue a couple of times fairly recently, not necessarily specifically defining ascertainable loss that I could see, but referencing a loss that is measurable, referencing getting less than what you bargained for. Goes right into actual damages. That is defined in 714H.2, sub 1, meaning all compensatory damages caused by the prohibited practice that are reasonably ascertainable in amount. Going into the second issue with regard to the statute, if there's a finding of consumer fraud, then the actual damages may be trebled if there's a finding of clear, convincing, and satisfactory evidence that prohibited practice constitutes willful and wanton disregard for the plaintiff. That's 714H.5, sub 4. No doubt the court's familiar with those terms. I would submit here there is not substantial evidence of a prohibited practice. The issue raised by the Grahams was that there were fraudulent billing practices. This was a general contractor, homeowner dispute, fairly common in the state of Iowa. The contract was for a renovation of the home and a remodel. The main issue that drove the litigation, and there was significant testimony, evidence, and argument at trial, was this a contract for a fixed price? Was this a contract for time and materials?
And doesn't that definitely need to be resolved before you can go to some of the other issues?
I don't think it does, Your Honor, and here's why. Because the evidence in the testimony of Jacqueline Graham was that the Grahams had agreed on July 31st was when the last version of the estimate came in. Contract was signed August 1st, 2019. They had agreed to a certain scope of work, and at that time the price was $136,000 and change. Afterwards, and the evidence at trial was they agreed to a little over $140,000. That's not in dispute.
Making an argument to the jury. There was no special interrogatory on this, correct? So isn't it reasonable to assume that a jury could have had substantial evidence would support a jury's finding that perhaps it was time and materials, and that would explain their verdict?
And that's apparently what the jury did here. So I don't disagree with that at all.
Interrogatory, right?
And in the contract, there was no reference to a labor rate. There was no reference to a specific quote for materials. Going back to the issue on the fraud, the expectation, what was the expectation? What was bargained for? They bargained for a remodeled house with an addition at a little over $140,000.
Didn't you just establish that the jury could have found that it was a time and material situation as opposed to a fixed price? Okay, so they could say that what you just said is incorrect.
Contract claim, as I would submit. The fraud evidence, the evidence of the fraud going to the ascertainable loss was what I was trying to get to is they agreed that they would pay $140,000, and that's what they paid. They didn't pay any more. They didn't pay any more than that. They didn't pay the last bill of $18,000. And the jury found against my client on that issue, very similar to the Okoboji Classic Cars case, in that there was no recovery for the defendant in that case. The defendant there was sued for consumer fraud and counterclaim for breach of contract, didn't get paid their last bill, approximately $65,000. Found against at trial. That's what happened here.
Describes the sort of situation where, because it's a time and materials contract, that it could have, the amount that they actually owed under the situation might have been less than this 140, quite a bit, if they hadn't been overbilled by your client. That's their point, right?
And my point on this argument would be, where's the evidence of fraud? There's no representation of you were going to be charged $45 an hour. That was nowhere in the estimate. That was nowhere in the contract. That was nowhere in the emails or the text messages while this project was ongoing. That was one reference to $45 an hour in.
Kind of at the outset, there's an agreement that this work is going to be done. There's an overall estimate of $136,000. There's a breakdown of items, but there's no labor rate, there's no materials rate. They agreed to that. If that work had been completed, then they would have paid that, and that would have been the end of the matter. And the problem is that your client later misstated or falsely stated the labor rate. Is that?
Respectfully disagree that he falsely stated the labor rate. He provided information. That's exactly it. He provided information. The dispute arose. The last bill was dated May 15th. Immediate questioning from the Grahams. My client cooperated. He responded to emails. He answered questions. He provided 151 pages of receipts and invoices in an attempt to work through this and resolve this issue. And it's right here. I've got it. I thought.
Still feel like we're the jury here. For the sake of argument, let's say it's time that the court determines that it was a time and materials situation. How does that change your argument?
It doesn't change my argument in the terms of there's no violation of 714H here. Again, because there's no ascertainable loss. They expected to pay 140, they paid 140. They got what they were expecting. So there's what's measurable. I'm sorry?
That it's time and materials. Let's say that the court is persuaded it's time and materials. The argument you're making is as if it is fixed.
Okay. In the email where this arose regarding the time and materials, this is in the amended appendix, page 178 and 179. It's an email from Josh Bradshaw to Jacqueline Graham on Wednesday, May 20th, 5 days after the issue arose. He details it out right here. Here's what the hard costs, the hard subcontractor costs were. Here are the labor hours. Here's what it would be at $45 an hour. The total is $163,942.
There's no representation of a labor rate ahead of time. Is that it? There was no, and therefore it really couldn't have been fraud as to the labor rate being charged because there was no representation before the work was done as to the labor rate.
They had charged $45 an hour based upon this information, appendix page 179. The time and materials would be $163,900. And that's where he gets the reference. There was no profit on this. He took a bath on this project. He never represented he would not make a profit. He never represented a certain labor rate. It's all right there on page 179. And I would submit that there's no substantial evidence of intent. There's no substantial evidence of the ascertainable loss. I think that's extremely important as it relates to the Okoboji Cars case. And one of the issues that we raised in the further review petition was that the holding here by the Court of Appeals is in direct conflict with that case. These cases are extremely similar. In fact, in my petition for further review, I referred to the facts as strikingly similar. and I would stand by that today. In that case, there was a contract for $45,000 for a restored car. The plaintiffs, fraud claimants paid $45,000. They got a restored car. They also got a bill for $67,000 at the end that they didn't pay. They sue for fraud, counterclaim for breach of contract, exactly like here. At trial, bench trial there, jury trial here, no recovery on the breach of contract for more than $45,000. Exactly what happened here. The evidence in that case was their expectation, as this court referred to it, was to pay $45,000. That's what they paid, nothing more. Here, it's very clear the expectation was to pay $140,000, and that's what they paid, and nothing more.
Challenge the consumer fraud verdict as inconsistent with the breach of contract?
I believe that's incorrect, Your Honor. I believe we raised that on the motion for a new trial. The motion for judgment notwithstanding the verdict and the motion for a new trial as inconsistent in the terms of, I believe the standard or the issue in the case law was not affecting substantial justice. I think, in my 2 cents is the breach of contract claim, they sued for poor work. They got a judgment for that. They're going to get paid for that. They could have also sued for being overbilled. They didn't pursue that on a breach of contract. They've pursued that under the fraud claim.
This question, do you have any disagreement with the Court of Appeals' use of the punitive damages statute to sort of analyze those in similar ways?
I don't have much of a disagreement with that in terms of willful and wanton. What I would say is, and I think this court needs to decide in this case, and it hasn't decided, is what is the evidence necessary for willful and wanton? Actual malice or legal malice, there's no claim of actual malice here. The legal malice, is there a conscious disregard? There still has to be intent. And that's one of my points. There has to be more to this statute than a breach of contract claim, than a negligence claim. There has to be more to it. These standards have to mean something with regard to the willful and wanton conduct. And beyond substantial evidence, what does the statute say? It says clear, convincing, and satisfactory evidence. Again, I would say, where is the evidence of fraud?
Could you address the idea that there were 27 instances of erroneous billings, and that, if you had evidence of a repeated effort by somebody to overbill, it seems like to me that could support an idea of fraud and therefore punitive damage standard?
If you go through those, if you look at those, I don't have it right here, and I can look at that for rebuttal. The 2 of those 27 instances, their claim at trial was, hey, we were overbilled by $40,000. Reducing what we didn't pay you, the fraud should be $22,000 and change. If you go through those 27 items, 2 of them make up almost the entirety of that $40,000, which was this labor rate issue. So it goes back to the same. It goes back to the same issue. There were disputes over, and some of this gets into the contract case and the expansion of the scope of the contract. For example, the Grahams had paid for flooring. No dispute on that. They had paid, but they paid for more flooring because the flooring of the project expanded from its original scope. So you kind of get into intertwining those issues. But to your point, I would say nearly all of that damage claim is the labor rate and the claim that they were overcharged for the labor rate.
That there is no evidence of an ascertainable loss, does that take care of the treble damages? 3 times 0 is 0.
Yes, it does. I think if this court reverses on that issue, then the entire fraud judgment goes away and the attorney fee judgment goes away. The only basis for the attorney fees was under the fraud statute. And so $10,000, it was a $10,000 fraud judgment, times 3 was 30. The fees ended up being about $25,000 or so. That all goes away. The remaining judgment stays, of course, that's not an issue, $16,000, and they'll be paid on that, but I would agree with you on that. I would like to talk about just the behavior at the end of this. I want to stress this. He provided information. He answered questions. He didn't put his head in the sand. He didn't ghost them. He offered to meet with them. That's not evidence of an intent to deceive. That's not evidence of an unreasonable character. He wanted to try to work this out, and I would respectfully submit that the policy of the law should be that we want people to work these out. We want to converse. If this verdict, or if this ruling stands, if you're a general contractor in Iowa, you read this, you say, wow, this guy got sued for fraud because of these information.
Looking at a jury verdict, right? And shouldn't we, as an appellate court, look at that and give deference to that?
If I may finish here, I see my time's up. I would say this, let's go back before the verdict. This should have been a motion for, this directed verdict motion should have been granted before this got to a jury. And I think that the standard on that is substantial evidence to support each and every claim. And as I've said here for 15 minutes and in the briefing, we respectfully submit there's not. So this shouldn't have gotten to a jury. Thank you.
Thank you. Now it's time for Mr. Hermsen.
May it please the court, counsel. My name is Zach Hermsen. I have the privilege of representing Barry and Jackie Graham, the homeowners in this case. This is a case about a contractor that took advantage of some homeowners and did it by adding fraudulent billings throughout this project, presumably with the belief that it wasn't going to be caught. It was presented to a jury.
Ahead of time, what labor rate was promised?
There was no labor rate promised. And what?
How is it they're a fraud then if there was no labor rate promised? And how can you even say it was time and materials based on, ahead of time based on a certain labor rate?
If it's a time and materials contract, there has to be a labor rate because something has to be paid for the time. What the Wells Dairy case says is that extrinsic evidence is, in modern Iowa law, essentially always coming in to interpret parts of the contract that are not directly addressed. So to suggest that this jury could not use as substantial evidence what the labor rate is on this case, that the jury could not use the contractor's own words, even if it's after the fact, if it's in the middle of the project at the beginning, I just don't think that's accurate. I think the Wells Dairy case says that's absolutely evidence the jury can look at.
Fraud, though. I mean, the fraud requires a representation beforehand that they rely on.
The statute reads that it has to be one of these improper acts. It doesn't necessarily have to be fraud. So it's called the Consumer Fraud Statute. But what it has to be is deception, an unfair practice, fraud, false pretense, false promise, a misrepresentation, a concealment, suppression. That's broader than kind of our general understanding of the term fraud. It is called the Consumer Fraud Act, but it's written very broadly.
I'll give you credit and say everything that you're talking about happened up to that point. Tell me what's jaw-dropping to get willful and wanton. I think all of us know that that's a tough burden to meet. Tell me what's your best willful wanton evidence, even, and I'll disregard at what time it was out there.
There's a lot of it. I would encourage the justices to go back and look at the direct and cross examination of the contractor in this case. It made no sense. From beginning to end, it made no sense. So day one of this trial, essentially the entire day was this contractor spent explaining why the price of this project went up. And
what was willful and wanton?
So I'll list our damages, which I think simply the mere fact of these damages is willful and wanton. But I also want to emphasize the point I was trying to make there is that the testimony did not make sense. It came across as a contractor that was absolutely trying to cover his tracks. He spent the whole time on day one explaining the contract went up because in October and November, we dug up a big root ball. The dirt was really compact. So all of these things, I won't go through all of them right here, but he said all these cost things, it just went way up on the project. But then when presented with an email after all of that, that said, he emailed the homeowner and said, no cost changing decisions have been made on this case. The project has not gone up.
What? Are you kidding me? Where's the willful wanton?
August 1 of 2019, the contract is signed. Okay. I ask at trial, the contractor, "Sir, did you do any work on this project before August 1 of 2019? He says, "No." It's right there in the transcript. I asked the Grahams, did they do any work on this project before this contract was signed August 1 of 2019? No. In discovery, we asked for time cards. We asked for timesheets. Tell us what work you did, your labor you did that you built on this project. They gave us a spreadsheet that had like total hours per month. July of 2019, 35 hours he billed on this project. It wasn't worked. It's fraudulent hours that were billed to this individual that both parties admitted were not actually worked. So at a minimum, we've got hours that were made up.
Whatever work they said was done in July of 19, even though they denied doing anything until 8, was that work that was indeed done, but maybe on a different date? What kind of work was it?
No work was done in July. So the spreadsheet says July, and it lists the name of the contractor, and it said like 35. It has the name and the hours, and it just says 35. We have no other information besides that. And then in discovery, I said, I'd like your contemporaneous timesheets on this project. They said, this is what they gave us. They didn't object to it. They gave us nothing. They just gave us this spreadsheet. And we said, well, okay, apparently that's all they have. They didn't object to it. They didn't say there's more out there. We get to trial, I cross-examine. He says, oh yeah, we kept contemporaneous time cards. I said, why didn't you give that to us in discovery? He said, well, you didn't ask for it. I said, yeah, I did. And then he said, oh, well, I decided it wasn't relevant. So that's what the jury heard. They said, we've got these fake hours, 35 hours that were billed that you said you didn't work. The Graham said you didn't work.
How do they build?
Bills, the way he billed is labor and materials. Sometimes it was labor, sometimes it was materials, but it was generally lumped together. So it was almost impossible to pick out how it was billed. But on the issue,
You know, it was billed.
we asked him in discovery, what hours did you work on this project and bill to these clients? And this is what he gave us. The jury is entitled to assume that what this individual is saying is true. Maybe one jury could disagree with it and say, you know what, maybe he made a mistake, but there's absolutely substantial evidence for them to say, these are fraudulent hours. And what he did is he was sloppy and he billed this project however he wanted. Whatever felt right on this particular item, that's how he billed it. Sometimes there's a 30% upcharge, sometimes there's a 25% upcharge. You can run the numbers. There is no rhyme or reason for how this project was billed. On the topic of what is this contract? It's absolutely, yeah.
You run the numbers. I ran the numbers based on the $45 an hour, even separate from what his email said. At the 1,630 hours, that's $73,000. I took the $90,000 in materials and backed out the 20% because it wasn't supposed to be adding the markup. That gets you $75,000. That's still $148,000, which is still more than what your client was ultimately paid, the $140,000. So even if you would have done time and material, it still seems like they paid less than that.
I'd have to go and run the numbers. We do have an exhibit that we gave to the jury that broke down what the total damages were. So that exhibit, so it's attachment A to the Graham's interrogatory. So it's exhibit, I want to say 10 or 11. They filed the Graham's interrogatories, and it's attachment A to that, and it breaks it down right down to the number. But essentially how the math works is the project cost of what the Grahams paid was just around $140,000. When you total up these fraudulent, these damages, and I can walk through them all in more detail. We've kind of been scattershot, touching on them here and there, but I can go through all of them. You add them up, it's $44,000 total. That includes items that were billed that were not used on the project. That includes the improper.
And billed $96,000? What was the total that should have been billed?
Billed is when you take, so if you take away the $44,000 from what they were billed, it ends up being $22,000 less than what they paid. So it was about $118,000 what it came out to. And that's what we argued to the jury. Our actual.
Presented with an estimate for $136,000 up to $139,000, and then they should have only been billed $116 or something, whatever that number was that you said.
Yeah, so 100, I believe right around 18, 120 thereabouts. Jury gave us less than half of that. They gave us $10,000. Very reasonable, very middle ground verdict. And I want to address something that said the expansion of this project from the original scope. I heard that on counsel's argument. This project didn't expand. Their definition of expand is, for example, contractor testified that, and I'm gonna explain this in the course of explaining why this is indeed a time and materials contract. The contract itself calls itself an estimate 14 times. You don't call a fixed price contract an estimate. It's not an estimate. You're saying I'm doing this work for a fixed price and this is the scope of work. You don't estimate that. It calls itself an estimate. Yeah.
I mean, I've dealt with contractors. I think most people have dealt with contractors. My understanding is that's pretty standard practice, is that you have an estimate, you understand construction projects are complicated. Things may be a little bit more, a little bit less. My experience is usually a little bit more. So why do you say that that's just not done? Because I don't have any reason to believe that's true.
Contractors maybe don't do that. It doesn't make sense if they do, because a fixed price contract says, I'm going to build this for $140,000. It doesn't matter if the price of materials goes up or down. It doesn't matter if it takes me 10 hours to do it or 5 hours to do it. This is the price I'm doing it for. The reason you provide an estimate is under a time and materials contract, we don't quite know where this is going. What you're saying and what you're committing to is, I'm gonna do this work at X amount of dollars an hour, and I'm gonna do it, I'm gonna pay you, I'm gonna charge you the materials and the labor, and that's why an estimate in that context makes sense.
Like industry practice on billing? Okay.
Expert Mark Parley was actually designated for that, and
On a fixed contract.
correct, our expert Mark Parley, who is a contractor, came in and did actually testify to that.
What additional evidence, or what evidence supported the willful and wanton above the compensatory damages?
So the damages, willful and wanton, it can be actual malice or legal malice. And I agree with counsel that I don't see any distinction between the standard articulated in this statute and the standard articulated in 668. So actual malice, meaning I don't like you, I'm targeting you for some reason. Legal malice, meaning a reckless disregard for someone's rights. If we give the jury credit here for their findings, which are that this contractor billed for hours that weren't actually worked, this contractor billed a labor rate that was improper, this contractor billed all this stuff.
Consumer fraud statute, and you get compensatory damages if you defraud someone in that project. But what takes it above then to allow you to have trouble damages? Doesn't that need to be a higher standard than the underlying fraud that supported the original claim?
That's a quintessential jury question. What constitutes willful and wanton? Was there actual malice here? Was there, I can't think of many consumer fraud claims or any claims where the contractor is going to get up and say, you know what, I meant to do this.
There are very few cases really where punitive damages get to the jury. It's a pretty high threshold, right? And this this strikes me, kind of stepping back and looking at the case, this doesn't strike me as an unusual dispute between a homeowner and a contractor. Sounds like your clients were in the right, but were they so much in the right that it's one of these rare cases that it's punitive damage worthy?
Construction industry needs to look in the mirror if this is not a rare case, because this is a case of absolutely pathetic billing. If it wasn't intentional, then it was absolutely a willful and reckless disregard for someone's rights, because the way it was billed is however he wanted to. There is no rhyme or reason. That's what's tough to articulate in 15 minutes, is that you go through each one of these bills, they don't make sense. The way he billed this, you look at the materials. Well, this material cost $100, he billed him $300. This material cost $100, he billed him $150. There's no rhyme or reason.
If we find that this is a fixed price contract, does Poller control on the statutory damages issue?
No, it's because, and I broke this down in my brief, and I'm going to try to do it in 1 minute and 20 seconds here. The kind of the simplicity of this appeal is no matter how you view this contract, which it's very hard to view this as a fixed price contract, but if you do, the damages are, we broke it down for the jury exactly why the actual cost on this project shrank. It's the fact that the Grahams purchased all of the flooring themselves. That was $6,500 worth of flooring approximately that they purchased themselves. Even under a fixed price contract, if the scope of the contract shrinks, you said under this, $140,000, I'm going to do A, B, and C, but I'm no longer doing C. We agree that you're going to do C instead, homeowner. That has to be reflected on the contract, and we cited the cases in our briefing. So what should have happened in this case is they should have paid less even under a fixed price theory because the scope of this project decreased. They didn't because these fraudulent charges were added onto it. And by fraudulent charges, there are all kinds of instances. For example, the root ball. I talked about the root ball. He actually testified at trial that he added more charges to this contract because the dirt was too compact. He said he got in there and the dirt wasn't as loose as I thought it was going to be. It was really compact. That expanded the scope in his reading of it. An attic ladder. He agreed, the very first document my clients gave him when they were talking about this was, I want you to build a new ladder up to my attic. He put in the contract, demolish ladder, okay? Client, no, she didn't catch it that he didn't say demolish plus build, but he then said after the fact, I'm expanding the scope of this contract because I didn't specifically agree in here to build you another ladder. What do you think she was gonna do, not access her attic? Never get to it? Of course that was within the original scope. So even under the fixed price theory, those actual damages absolutely are still stand. I see I'm over my time. If I can very, very briefly wrap up. I just want to emphasize, Your Honors, there was a mention to deference to the jury. Every legitimate inference that may fairly and reasonably be made should be made in the Graham's favor on this. The evidence should be viewed in the light most favorable to the Grahams. That's Bradberg. Considerable weight should be given to the jury and the trial court's assessment of credibility of witnesses. Napstad Custom Homes. We should liberally construe the jury's verdict to give effect to the jury's intention and harmonize the jury's answers if possible. And then the Consumer Fraud Act itself, the Cuddy's Camping case, says this is a remedial statute, and as a result, it needs to be liberally construed in favor of the consumer. In this case, the jury worked hard over a 4-day jury trial, listened to the evidence, entered a very reasonable verdict. That gave us less than half of what we asked. The trial judge listened, affirmed. The Court of Appeals heard oral arguments, read the briefing, and affirmed. And we'd ask that this court affirm the hard work of this jury, this trial judge, and the Iowa Court of Appeals. Thank you.
Thank you. Off the top, this discovery issue that was mentioned is totally irrelevant. That was raised at trial. There was a motion for sanctions. There was a motion to restrict our evidence. There was a motion to strike proof. That was all denied. That was a discovery issue. It has no relevance on this. Regarding
Though, did it make it?
Evidence, but the jury did not hear that record that was made. That was made when the motion for sanctions that was made outside of the jury, and that's in the transcript. To Justice Oxley and Justice May's questions, the list of items that starts at appendix page 497, and 9 of these 27, in my quick review here, have to do with labor charges. I didn't have a chance to add up the amount, but I would respectfully submit it's 95% of their total damage claim or this labor issue. And if you look here, what they've done is took that 1,630 hours, and they took that times $15 an hour. They seem to think, in their view of this was time and materials. We should have been charged $45. We were charged $60. Again, there was no representation of that, but that's how they calculated that, okay, to answer that question. And that goes away. Again, I would respectfully urge the court to look at what is an ascertainable loss here, and particularly with Jacqueline Graham's testimony, page 666 of the appendix. The question was, so you have paid pretty darn close to what you originally agreed to, correct? Answer, correct. That creates the expectation, I would respectfully submit to this court, that they were to pay $140, and that's what they did pay. Again, where is the intent? There was questioning here regarding can you show us some willful and wanton conduct here? I would respectfully urge this court to give some definition to these standards. Clear, convincing, and satisfactory. What does that mean? That has to mean something. That has to mean more than a standard breach of contract, a disagreement over contract terms. The standards have to be enforced. The statute is different from a breach of contract case. It has to mean there has to be something else there.
This, maybe you can help us then, because I'm trying to figure out, you know, if the jury did feel that you're, based on the evidence presented, that your client was fraudulently billing the Grahams, I'm not sure what more you know, I'm trying to figure out what the threshold would be if that's not good enough.
Your Honor, I've been trying to figure out what the jury did with this for 2.5 years, since August of 22, when this verdict came down. And I would go back to what I said to Madam Chief Justice, is that this shouldn't have got to the jury. This directed verdict motion should have been granted, as there's not substantial evidence. And when it went there, it should have came back. I understand that trial court judges may be reluctant to do that. A couple other things just in cleanup. There was a question about the invoices. I would direct the court. The invoices are very clear. That's Exhibit G, beginning at page 234 in the record. There's 13 pages of them. There's no reference to an hourly rate anywhere in there. There was no representation at any point. And specifically, the one document they can point to, again, is page 179 of the appendix on this email. I would encourage this court, please, to review that carefully. He's not saying I was only going to bill you $45 an hour. He's saying that I need to bill $45 an hour to cover what my labor rates and my costs, and this is what the cost would be if it was a time and materials basis, which is more than what they ended up paying. Briefly, it's undisputed that the scope of the contract increased. There was a brand new electrical system in the house. Once they got into it, it was a 100-year-old home, essentially a new plumbing system. I don't believe that's particularly relevant to this case. That goes to the contract claim, which is not at issue in this matter. Again, would respectfully request this court vacate the Court of Appeals decision. Reverse the district court rulings denying the motion for directed verdict, denying the motion for judgment notwithstanding the verdict, denying and/or denying the motion for a new trial. And for all the reasons we've said, no ascertainable loss, no intent to commit a prohibited practice, and certainly no evidence of clear, convincing, and satisfactory evidence of willful and wanton conduct justifying trouble damages. I thank this court for hearing us in oral argument, and I thank this court for taking review of this case. Thank you.
The case of Bradshaw versus Graham is hereby submitted. We'll have a brief pause while we prepare for the next case in the matter of David James Hansen, magistrate.